Hello and welcome to this video on assault as part of the non-fatal offences collection. Now, for all non-fatal offences on this specification for A-level, we have 5 non-fatal offences. So they are assault under Section 9, battery under Section 9 of the Criminal Justice Act 1988, and then we have the Offences Against a Person Act 1861, Section 47, which is assault occasioning actual bodily harm, Section 18, which is inflicting or grievous bodily harm or wounding, and Section 18, which is inflicting grievous bodily harm or wounding with intent. So we're just going to look at the assault for this video. So non-fatal offences against a person are then a collection of common law and statutory offences. They don't fit together very well, of course. The OAPA 1861 offences come from a variety of other sources, but were collected together in a single statute. And the less serious offences of assault and battery common law offences, the sentence is provided under Section 39 instead. So an overview of assault, what we're going to cover is the definition of assault, what the actus reus of assault is, and what the mens rea of assault is. Starting, of course, with the definition. So it is provided in a sense under the Criminal Justice Act of 1988. So Section 39 tells us the common assault and battery shall be summary offences, and the person guilty of either of them shall be liable to a fine not exceeding level 5 on the standard scale, which is currently £5,000, to imprisonment for a term not exceeding 6 months, or to both. So this act has been developed because it is a common law, so it develops by cases and indeed textbooks, as you're going to see shortly. But the broad definition of assault is an act which a person intentionally or recklessly causes another to apprehend immediate and unlawful personal violence. So this definition was created in Smith and Hogan's criminal law, which has been adapted indeed by Fagan and Metropolitan Police Commissioner, and then confirmed again in Ireland and Burstow, cases we're going to cover shortly. So this definition was updated then in Nelson, where the Court of Appeals suggested that assault is what is required for common assault is for the defendant to have done something of a physical kind which causes someone else to apprehend that they are to be struck. So therefore there's no statutory definition of assault, but the courts know what the definition is through common law. Now the sentence is provided under Section 39 of the Criminal Justice Act of 1988, and like we said before, the maximum sentence of 6 months in prison or maximum level 5 fine, or both. So once we've come up with a definition in any application question, we then go straight to the actus reus of assault. We should outline first of all, so apprehends immediate and lawful personal violence, and explore each in depth while applying them. So the actus reus needs to be a positive act. It cannot be an omission, but it does require usually acts or words, but it's not necessarily for physical contact. That could be battery, of course. Now, actus reus is completed when the defendant does any act or says something which causes the victim to believe that unlawful force is about to be used against him or her. So fear of any unwanted touching is enough. It doesn't even have to be serious force. Of course, the reflection for the types of force used or threatened or apprehended will be reflected in the sentencing. Now, following Fagan and the Metropolitan Police Commissioner, this can be a continuing act or a series of linked acts. And so we've looked at the definition, we looked at overall what the actus reus of assault is. We're now going to break it down into what each of those things means. We're going to look at apprehends, we're going to then consider what immediate means, and we're going to consider what unlawful force or personal violence means. So we begin with apprehends. So of course, it is necessary that the victim apprehends force. Now you may get a little conflated with the word fears. Now they may fear force, but that isn't enough. That isn't necessary to prove assault, because it's difficult to prove the victim was scared. That would make assault a crime based on the feelings of the victim. Now the apprehension of immediate violence can be caused by actions or words. Even silence can constitute an assault, as we're going to look for it. We're going to look to, and words can also negate an assault, so you can cancel out an assault through talking. Now, all these things are going to be explored. So in Mead and Belt, one of the early cases on assault that we look at, It isn't the current position, but does outline that some people who gathered round another's house singing a menacing song of violent language. The judge in this case said no words or singing alone are equivalent to an assault, but this now is not the current position. In Wilson, the defendant shouted, "Get out the knives," when a physical fight developed under the defendant was charged under Section 47 of the Offences Against a Person Act 1861. Now we know assault can amount to ABH as well. But Lord Goddard stated that the words would by themselves amount to an assault. So of course we've got this idea that the case could be different, but assault is an underpinning element of ABH, and so we need to prove assault first. In Constanza, you will have looked at this case, but the defendant wished to form a relationship with the victim who didn't want to reciprocate, and Constanza subjected his victim to a prolonged period of harassment by repeated telephone calls, more than 800 letters, unwanted visits, and graffiti on their front door. Now, we've never taken any expressly physical or any expressly threats against her, but nevertheless she suffered clinical depression and fear of violence, and again, written words in this case could constitute assault. In Ireland, this gives us the idea that, again, this is a stalking case, but telephone calls or silent telephone calls amounted to assault. So this apprehension. Tuberville and Savage gives us the impression that words can also negate an assault. So if you say something which puts a condition on you threatening somebody, or I would do something if it weren't for this, then that can undermine an assault. So if I, for example, said I was going to punch you if you didn't have glasses on, well, if you have glasses on, what I'm really saying there is I'm not going to punch you. So in this case, the defendant struck a victim, caused him to lose an eye, and the victim put his hand on his sword and stated, if it were not assize time, which is when courts came to the town, I would not take such language from you. So he defended himself, but there'd been no assault. And this defendant placed his hand on his sword in this case, if it were not assize time, I would not take such language from you. In this particular case, then we've got the idea that he's saying, I'm not going to strike you because it is assize time. In Light, though, in 1857, this was a slightly different case, but again, contrasts with the decision of Tuberville, because the defendant here raised a sword above the head of his wife and said, were it not for the bloody policeman outside, I would split your head open. It was held there was an assault because he did fear force. The policemen were outside. Stevens and Myers gives us the impression that even raising a fist towards somebody could constitute an assault, in that they would apprehend battery. In Logden and DPP, a customs officer called on Logden to discuss his VAT returns, and Logden showed the officer a gun in a drawer and told her he would hold her prisoner until money owing him was repaid. He then handed her the gun, which was a replica and wouldn't fire, but he was charged with assault, and again, at the point he showed her the gun, she apprehended harm. That's enough. In Lamb, there was no assault, and this case comes up in a couple of different areas of criminal law. But the defendant here were playing with a revolver. Now in the chamber there were 2 bullets, but neither was opposite the hammer when the defendant in jest pointed the gun at his friend and pulled the trigger. The chamber rotated and the victim was killed. Now in this case the victim shared the joke, and there was evidence of this, and so as a result he believed the gun to be safe. There was no assault because the other person did not fear unlawful violence, thinking the gun couldn't shoot. So apprehend means to become aware of. It means to be aware of the danger. We need now to consider what immediate means. So normally this requirement means that a threat to use force in the future cannot be an assault. So for example, if I said I'm going to kill you next week, that's not an assault because there's a time gap. However, it doesn't necessarily mean all the time that very second or imminent, and the courts have taken a generous view of immediacy. Now, the courts have adapted this to include almost certainly the fear of possible future violence, but within reason. So what we're going to see is sort of a bit of kind of stalking cases and so on, where the fear of the unknown almost becomes immediate. So when the Smith and the chief superintendent of Woking police station, of course, this was a person who was stalking in essence, and because the victim didn't know what was going to happen next, then she suffered from depression. Now, The person stalking was convicted not for assault on the grounds that even though he could not attack her at that very moment, her fear was of sufficiently immediate and unlawful violence, and she was unsure what he was going to do next, and that was enough for this case. Again, if we look to Constanza, we know the apprehension was caused by the written word, but the victim has been stalked over an extended period of time, and the Court of Appeal decided the victim had to apprehend unlawful violence at some time in the future, not excluding the immediate future. And they did, of course. The victim knew that Constanza lived nearby, and she thought something could happen at any time, so that would satisfy the concept of immediacy. And then we've got a slightly unusual case in Ramos. Now, the defendant was charged with distributing racist letters threatening a bombing campaign that were threatening, abusive or insulting with intent to cause a person to believe that immediate force or violence will be used against them. Now, the district judge in this case decided that since no time had been mentioned for the proposed attack, this lacked immediacy, but the prosecution appealed on the point of law, and it was decided that the important matter was the victim's state of mind. Provided the victim believed something nasty could happen at any time, the defendant could be convicted. So we can see this idea of immediacy has been extended by the courts to include things which are not in the near future but the fear of the unknown, and that's enough for immediacy. The last element we need to look at then for the actus reus of assault is what constitutes unlawful force or personal violence. So quite simply, we can come up with some examples. So we can have things like medical attention, we can have self-defense, we can have lawful arrest, so we can have disciplining a child to some extent. Now, those kinds of things would be lawful and therefore wouldn't be unlawful. But of course, we discussed earlier on this idea that could be any unlawful personal violence. It could be, for example, fear of unwanted touching, and that's sufficient. The force or unlawful personal violence, which is fear, doesn't need to be serious. And we looked at many examples, so raising a fist like in Stevens and Myers, but we can also have throwing a stone at the victim which misses, pointing a loaded gun at someone within range, or making a verbal threat saying, "I'm going to hit you." They would all be sufficient for unlawful personal violence or force. So as with every crime, we've now considered the actus reus of assault. We then need to consider what the mens rea of the offence is. And this, quite simply, is the intention or subjective recklessness to cause apprehension of immediate and unlawful violence or personal violence or force. So this essentially means that mens rea for assault can be satisfied in three ways. So we can have a direct intention to cause apprehension of immediate and unlawful violence. So this means it was the defendant's main aim to cause apprehension of immediate and unlawful violence. This is usually easy to spot in any scenario question. Or it could be oblique intent to cause apprehension of immediate and unlawful violence. So, for example, it's virtually certain that the defendant's actions would cause apprehension of immediate and unlawful violence, and the defendant knew this. So, for example, like running into a crowd with a knife, for example. Of course, it'd be virtually certain, even if it wasn't the main outcome or main intention. And then we have recklessness as to causing apprehension of immediate and unlawful violence. So what we're saying here is there's a risk of the victims apprehending the harm, and the defendant took the risk anyway, so they knew about this risk but took the risk anyway. So this idea of subjective recklessness was confirmed in Cunningham, so we don't use Caldwell objective recklessness, i.e. from the reasonable person's perspective. It needs to be from the perspective of the defendant themselves. Now, the defendant here was not convicted because he wasn't malicious in maliciously administering a noxious substance. Indeed, he wasn't even reckless. Now, reckless needs to be that the accused has foreseen the particular kind of harm and took the risk of it anyway. He didn't know. He wasn't aware of the risks and therefore could not be convicted of the offence. And this is the test for recklessness that we use. Venner is another example of recklessness. In this case, it was a conviction of assaulting a constable, so outside of a pub in a scuffle. Now, the defendant appealed on the ground that recklessness was insufficient mens rea for the offence, but his conviction was upheld by the Court of Appeal. And the offence of common assault, remember this is either battery or assault, they said requires intention to cause the victim to apprehend immediate and lawful personal violence or recklessness as to whether such apprehension is caused. and indeed the same for battery. So recklessness is sufficient for these offences, and then it confirms this. We have sprat as well. So the defendant fired an air pistol from the window of his flat, aiming at a target in the yard below. Now, one of the shots hit a 7-year-old girl playing in the yard who had not known he was there. Now, his conviction for assault causing GBH was quashed. This confirms subjective recklessness test in Cunningham is needed for non-fatal offences, so not objective, but subjective recklessness. So in the Savage and Parmenter, this was a joint appeal, 2 separate cases, but with similar point of law. Now, Savage intentionally threw beer at a victim, but the glass left their hand and struck the victim, causing a cut. In the other case, Parmenter roughly handled his child, causing the breaking of arms and legs. Now, there were lots of other key rulings, but these co-heard appeals decided and confirmed that Cunningham's subjective recklessness applies to non-fatal offences against a person. So this is what we use going forward. So that concludes the overview of assault. So we looked at the definition, we looked at what the actus reus is and broken that down, and we looked at the mens rea as well. Now, of course, when we apply this to problem questions, we conclude, and we should also always outline what the potential sentence is going to be if they are guilty or not guilty. All right, thanks for watching.